Hi, I'm Amanda Robinson. I'm a Senior Solicitor here at the Law Office of Conrad Curry. Today I'm going to answer some common questions about workers' compensation. Most New South Wales workers have three entitlements under the workers' compensation system. The first one is to payments of reasonable and necessary medical expenses. The second one is an entitlement to weekly payments of compensation. The third payment is for lump sum compensation for a serious injury that is permanent. For physical injuries, that is 11%. For psychological, that is 15%. Some New South Wales workers have retained a fourth benefit, and that is to pain and suffering. Those workers include police officers, ambulance workers, firefighters, and coal miners. Given the work they do, retaining the right to pain and suffering is understandable. A common question I'm asked is whether a worker can choose their own doctor. The answer is most certainly yes. We suggest you go and see your own GP as soon as you suffer a work injury, and of course get a work cover certificate. Section 248 of the Workers' Compensation Act provides that an employer cannot dismiss an injured worker due to a work-related injury within 6 months of the injury. The employer is able to state that there are no suitable duties available. That means, whilst you're still employed, you're unable to return to work until you have recovered. In that instance, you'll be entitled to weekly payments of compensation. We never recommend you resign if you have a work injury. If work becomes too hard, in that it's too physically demanding or repetitive, and your injury is starting to flare up again, go back to your GP, get a work cover certificate. That work cover certificate can set out whether you're capable of staying at work or what restrictions need to be in place for you to stay at work. Or if you can't return at all, you can get your weekly payments from the insurer. If you resign though, you may be foregoing those weekly payments because you're rejecting what may have been called a suitable job. A work environment can lead to a psychological injury due to lack of support, bullying and harassment, poor workplace relationships, or a traumatic event such as an armed robbery. It is important to remember that a psychological injury may not be accepted by the insurer if it relates to reasonable action taken by the employer, such as a performance appraisal, transfer, disciplinary action, retrenchment, or dismissal. It is very important to be able to distinguish what has led to your psychological injury. If your GP believes that you may have a psychological injury or you need some time off work, then a work cover certificate can be completed and sent to your insurer or the employer. Unfortunately, there is nothing in the workers' compensation legislation preventing an employer making an employee redundant following a work injury. However, it must be a genuine redundancy. That is, no one is required to perform your position anymore. If you don't think it's a genuine redundancy, you need to seek legal advice immediately, as there are strict time frames in this area. Usually only 21 days.